Hey everybody, Todd Vandermeide back again for another edition of Freedom Steel, former NRA contract lobbyist and Illinois gun law guru. We have breaking news out of Virginia. Cue the alert. So today, we're just going to jump right to the answers. It is so good. There was this case of Brown v. ATF and Merrick Garland, and this is a challenge to the prohibition on 18 to 20-year-olds being able to purchase a handgun from an FFL. And so let's jump right to the end where the really, really good stuff is. In summary, because plaintiff's conduct, the purchase of handguns, quote, falls within the Second Amendment's unqualified command, and the challenge statutes and regulations are not consistent with the nation's historic tradition of firearm regulation, the court finds 18 U.S.C. subsection 922 B1 and C1 facially unconstitutional and as applied to plaintiffs. Plaintiffs, having demonstrated there is no genuine dispute of material fact and that they are entitled to judgment as a matter of law, their motion for summary judgment is granted for the same reasons defendant's motion to dismiss is denied. There you have it, boys and girls. We have another win. And what's beautiful about this is this judge did a full-on analysis from top to bottom on the whole New York decision and everything else. And in doing so, he really did a great job of this. And we're going to pull out some of the highlights where, plaintiffs do not dispute that 18 and 20-year-olds who are law-abiding adults and not otherwise banned from firearm possession are not prohibited from possessing handguns. Defendants' specific arguments are likewise unavailing. First, the suggestion plaintiffs suffered no injury because a parent or guardian can simply purchase the gun and give it to an 18 to 20-year-old overly minimizes plaintiff's plight. So the ATF was urging a straw purchase, even though a gift to a family member is not actually considered a straw purchase, but they're bordering on, telling them, well, they can just go have somebody commit a straw purchase for them, and that solves the problem. That was kind of like what was argued in Ezell, where they said, well, you can't have a range in Chicago, but you can just drive across the border and go do that, which actually comes up later and I think is a much more significant part of some of the things that they're doing here. The government's suggestion erroneously draws too large a distinction between the right to possess and the right to purchase a firearm. Although the Second Amendment does not expressly protect the right to purchase firearms, that right must exist by implication if the right to keep and bear arms is to have its full meaning and effect. Common sense and logic tell us that unless one is the maker of guns, the right to keep and have a gun necessarily means that one must purchase it, steal it, be given it by another, or find one that another has lost, citing a case called Frazier. So here the judge completely gets it. He even includes making your own firearm. This is fabulous. And now he uses the Fourth Circuit opinion that we won earlier this week. The Fourth Circuit also dismissed the suggestion that a 30-day waiting period at issue there under Maryland law was not a sufficient deprivation to run afoul of the Second Amendment. Discussing the founders' use of infringed in the Second Amendment's text, the court left the issue undecided but noted the Second Amendment scrutiny is not exclusively reserved for laws that wholly or effectively prohibit firearm possession. This court therefore has no hesitation, concluding plaintiffs have sufficiently pled and demonstrated an injury in fact. The ban 18 U.S.C. 922 imposes on 18 to 20-year-old law-abiding citizens is a more significant deprivation than the 30-day waiting period in Maryland shall issue. There, the Fourth Circuit concluded, quote, the temporary deprivation that plaintiffs allege is a facially plausible Second Amendment violation in Maryland shall issue. Thus, the individual plaintiffs have standing. I mean, they attacked the plaintiff's standing. They attacked all kinds of stuff in here. And it just goes on. And they get into the ancillary rights. Remember, I've told you 27 words of the Second Amendment we need to make look like the Encyclopedia Britannica, because that's how we're really going to win. And they go on. The court's conclusion here is in line with the decisions of multiple federal courts of appeal, which, when asserting the textual reach of the Second Amendment, have held that the Second Amendment protects ancillary rights necessary to the realization of the core right to possess a firearm for self-defense, citing our friend Rhonda Ezell in Ezell v. Chicago. So congratulations, Rhonda. You got another mention in another court case. And so he goes on to talk about all that. And they pulled the same old worn out trick of what does the people mean, trying to argue that 18 to 20-year-olds are not the people, and the court summarily shut them down. Therefore, because neither the First nor Fourth Amendments exclude nor have been interpreted to exclude 18 to 20-year-olds, the court can discern for no reason to read an implicit age restriction into the Second Amendment's plain text either. Bingo. This guy is just, he's knocking them around like Negan with Lucille and a herd of zombies. And he goes on to state the government cannot meet its burden to show 18 U.S.C. subsection 922B1 or 922C1 are consistent with our nation's historical tradition of firearm regulation. He cites Blackstone. And that's what, Blackstone is what the other side always runs to. And he goes on to chastise them a little bit. Defendants spend time collecting state laws prescribing age barriers to the possession and purchase of firearms between the years of 1856 and 1993. However, here goes to a quote from Heller, constitutional rights are enshrined with the scope they were understood to have when the people adopted them, whether or not future legislatures, or yes, even future judges, think that scope too broad. It comes out about page 63, if I remember. Going on, the scope of the protection applicable to federal government is pegged to the public understanding of the right when the Bill of Rights was adopted in 1791. 1791. He goes on, defendants' reliance on mostly 19th century gun safety regulations as their justification in regulating the 18 to 20-year-old age group is misplaced under Heller and Bruin. At the time of the ratification of the Second Amendment in 1791, 18 was the age of majority for militia service throughout the nation, although in 1775, 16-year-olds were expected to fight in the Revolutionary War. So there you have it, boys and girls. Another big win out of a federal district court in Virginia. This has implications for Illinois with not issuing FOID cards to 18 to 20-year-olds under their own signature. And this is, he's enjoying the statute nationwide. I'm sure that Merrick Garland is going to appeal this promptly to the Fourth Circuit Court of Appeals. So we'll see what happens there. But he relied on a lot of their precedent for this. So this is a nice win on Freedom Fridays. So, hats off to the challengers here. They got a nice early Christmas gift here. We've got that. This has implications for Illinois and a bunch of other states. So please, trying to keep this one short, but wanting to get all the really good highlights out of this. Wanting to get all the really good highlights of this out and about for you guys. I will put a link to the decision below. And always, hey, today's the opening of the Gundies. If you can find time to go over there and, like you were a Chicago Democrat, vote early, vote often. You can vote every single day. I'm in category for 2A podcasters. We would appreciate your support. We're up against guys that have 500,000 subscribers, so just a good showing would be nice. But as always, like, copy, paste this video and share it around your social media. And as always, frag out.